Once a year. That's the entire federal requirement for how often a district has to put the procedural safeguards notice into a parent's hands, and in a year where nothing goes wrong, that's exactly what happens. It arrives, it goes in a drawer, nobody opens it. In a year where something does go wrong, the number is 5. Same district, same child, same regulation. What changed is which of 4 extra triggers the year tripped, and a parent who never read the packet doesn't know to ask for one of them. One right in that packet freezes your child's placement the second a parent files, even when the district is certain it's right. Park that.
This is Erica, and that number sits in one sentence at 34 CFR 300.504, paragraph A. A copy must be given to the parents only one time a school year. Then it turns on the word except, and 4 more occasions come out.
Last episode ended on the moment a progress report says a goal will not be met and the team sits back down under 324, and this packet is already on that table.
K here, 4 triggers, and the 4th is the one nobody uses. Upon request by a parent. That's the whole clause. No form, no reason.
Kai, a parent can just ask. Any Tuesday, no reason at all.
Has to be given. Paragraph 4 says upon request by a parent and stops there. The other 3 are narrower. Upon initial referral or a parent request for evaluation. Upon the first state complaint and the first due process complaint in a school year. And under the discipline procedures at 530, paragraph H.
And that middle one covers 2 different filings inside one numbered item. Worth knowing before you go counting.
Which is why I want teachers hearing one baseline plus 4 doorways, not a flat list of 5. The baseline is the quiet ear.
Yeah, and the line districts lean on is paragraph B. A public agency may place a current copy of the notice on its internet website if a website exists. May, not must, and not instead of.
Posting it isn't giving it. Different verbs, different paragraph.
Plain language, and in the parent's native language, and that rule isn't even written into 504. Paragraph D borrows it from 503, paragraph C. If the family's language isn't a written one, the district translates it out loud and keeps written evidence the parent understood.
Cynthia, that last clause is the one to sit up for. The evidence lives in the district's file, not the family's. So the question years later isn't whether the parent understood it. It's whether anybody can show it.
And this thing keeps getting called a formality. Paragraph C says the notice must contain a full explanation of 13 numbered topics.
13. Independent evaluations, prior written notice, consent, records, complaints, mediation, where the child sits while a complaint is pending, interim settings, private school at public expense, hearings, appeals, civil actions, attorney's fees.
6 of those 13 change how a meeting actually goes. Those 6 are today. One of the 6 has a clock inside it. We're not naming which one until the end.
Okay, and right number 2 is what puts the packet into a hand. Prior written notice built in episode 10, so I'm not rebuilding it. The clause that matters today is 503, paragraph B4. Every one of those letters carries a statement that the parents have protection under the safeguards and the means by which a copy can be obtained.
And notice runs in both directions. Paragraph A covers a proposal and a refusal. The letter that says no is a notice too, and it still has to point back at the packet.
So the system does tell you. Once a year, plus every time it tells you no.
The chat is pushing up the question I was planning to dodge, so we'll take it. If these are the parents' rights, why does a teacher need to know them? The honest answer isn't politeness.
You're the one sitting at the table when they get used.
Right. Every one of these 6 moves runs through a document a teacher helped write or a meeting a teacher sat in. A parent who files isn't filing against you. They're filing about the record.
Then reading the packet isn't a risk to you. It's the map of a room you're already standing in.
Same room, better map.
One thing before the next part, and then we move right on. If any of this is clicking, tap that like, hit subscribe, and ring the bell for the next one. It takes a second, it costs nothing, and it helps more than you would think. different animal entirely now. Professor Sorensen is at the desk for rights 3, 4, and 5 because those are the ones that stop being paperwork and start being a case.
Yeah, and families read them as 3 options on a menu. They aren't. Picking the wrong one first is how a year disappears.
Right 3, plainest version. File and your kid's placement freezes where it is.
Almost. It opens with accept as provided in 533, the discipline path, and closes with unless the agency and the parents agree otherwise, and it's key to a filed complaint under 507. Unhappy isn't a trigger, filed is.
So it isn't automatic the moment a parent is unhappy.
Okay, this is the one I promised in the cold open, and it deserves reading whole instead of as a slogan. Except as provided in 533 during the pendency of any proceeding regarding a due process complaint requesting a hearing under 507, unless the agency and the parents agree otherwise, the child involved must remain in his or her current educational placement. Current. That word does all the work, and getting it backwards costs the family the thing they filed for. That cost is coming.
Current meaning the placement you have, not the one you're asking for.
The way stay put gets described is, forget that. Think about disputing a charge on a card. The disputed charge is the placement change. The call is the filing. The freeze is stay put. The investigation is the hearing.
Okay, but what freezes when there's nothing on the statement yet?
That's my case. A 5-year-old never enrolled anywhere. Parents disagree with the offer and file. What freezes?
Nothing, and paragraph B says so. On an application for initial admission, the child, with the consent of the parents, must be placed in the public school until all the proceedings are complete.
Huh, then I've been teaching this wrong. The invariant is that filing fixes where the child sits. What changed is whether there's a placement to fix. That's where my card breaks down. I'd been calling paragraph B an exception. It's a different question.
So 1 question, not 2. Already somewhere? Freeze it. Never enrolled? Placement with consent, then argue.
1 clean step, plain words. Filing holds the placement a child is in, and where there isn't one, it puts the child in the public school with the parents' consent.
And paragraph C is the edge nobody quotes. A child aging out of Part C at 3, and the agency need not keep providing the Part C services. If the child qualifies under Part B and the parent consents, the agency provides what isn't in
Dispute. Only the undisputed ones. The rest waits.
the undisputed ones, which is the one place the freeze quietly doesn't reach.
Walk a hallway on a Tuesday in the middle of a filed case and nothing looks different. Same room, same aide, same seat. The freeze is invisible from inside the building.
Nobody outside this desk says current educational placement. They say the freeze. Better word, I mean better if you remember it's the placement you already have. Pause here and open your district's packet. Find the stay put page. I'll wait.
Right 4, 2 plausible rules, 1 real. Either a parent must try mediation before filing, or mediation can't be used to delay a hearing. Which one is in the regulation?
First one. Every system makes you knock on the cheap door first.
The second, paragraph B1, voluntary on the part of the parties and not used to deny or delay a parent's right to a hearing. Nothing requires mediating first.
Huh. I had that exactly backwards.
Yeah, and paragraph B4 puts the cost on the state. Not the family, not the building budget. Does the mediator have to come from outside the district or only be neutral?
Honestly, I'd have to check before I said it out loud. Park it, I'll come back. Voluntary on both sides is the part I want heard though. If you hold one thing from the scene, hold that. A district that won't sit down can't be made to, and the clock keeps.
Right, and that's the problem. Cheap door, expensive clock.
Go ahead.
Paragraph B8. Discussions may not be used as evidence in any later hearing. That protects candor, and it leaves a family with nothing on the record. But a settlement under B6 is binding, and B7 makes it enforceable in state or federal district court. Not a handshake.
So, as I was saying about the clock, 2 years, and it's the number people get wrong most.
And it isn't in the complaint section, which is where everyone looks. 507, paragraph 2, not more than 2 years before the date the parent or public agency
Filed 2 years before the filing.
knew or should have known, not filed. The clock starts the day somebody had reason to know,
Knew or should have known. Not the day it happened. Different dates.
and a state may set its own explicit limit, which then governs. So 2 years is the federal default, not the answer everywhere.
There's a case pattern I keep coming back to on Right 5. Want it?
The one where the sufficiency letter shows up? Go.
Composite, not a real family. Call her Marisol, mother of a third grader in a small rural district. Files in the spring, 40-something pages attached, describes the problem better than most attorneys.
Did she fill in the proposed resolution?
Left it blank. Their counsel challenged it as insufficient in writing inside the 15 days paragraph D1 gives them. The next month went to an empty box instead of her son.
That empty box is the teachable part. Paragraph B lists 6 required contents, and number 6 is a proposed resolution to the extent known and available. Blank isn't to the extent known.
Name, address, school, homeless contact information. The problem, the proposed fix. 6.
And a complaint is deemed sufficient unless challenged in writing inside those 15 days. Most never are. An empty box invites.
Hang on. Mediation or a due process complaint. Which door does a parent pick?
Depends, and it changes the answer. Is the family fighting about a disagreement or about a deadline?
A deadline. She found out in the spring. 2 years from the spring. Call it 9 months of slack. Maybe less.
Okay, 2 ways to answer. 1 safe. Filing fixes a date on the record. Mediating fixes nothing. With a clock that close, file first and mediate after. Nothing stops a family doing both.
And mediation is available for any matter under Part B, even before a complaint is filed.
And the one I parked. Paragraph C1. A mediator may not be an employee of the SEA or the LEA involved with the child. Outside and neutral. Erica, both halves. Professor Sorensen, thank you. What I'm keeping is paragraph B, that an initial admission has nothing to freeze. That's the correction this desk needed.
She read the whole sentence out loud, twice. Some of us were still on the first clause.
Twice is how you avoid Kai's version.
Which leaves right number 6. And the one clock in this packet that can quietly cut a family's money to nothing before anybody sees a hearing officer. "10 business days. That's the clock. It sits inside right number 6, and almost nobody in a school building can tell you it exists.
Yeah. 300.148. Parked back in subpart B, nowhere near the other safeguards. Part of why it gets missed.
Different subpart, same packet. Topic 9 of 13.
The situation it's written for is one every teacher has watched from the hallway. A family decides the district isn't delivering, pulls the child, enrolls somewhere private, then asks the district to pay.
And it isn't automatic either direction. Paragraph A says this part does not require an agency to pay when it made FAPE available and the parents simply elected a private school. Paragraph C reopens the door. A court or a hearing officer may require reimbursement if that officer finds the agency had not made FAPE available in a timely manner prior to the enrollment, and that the private placement is appropriate. May. 2 findings. Both, not either.
2 findings, 1 verb, may, not shall.
10 business days, and it's paragraph D2.
Erica, D12. Paragraph D2 is the evaluation 1.
D12. You're right, and it matters. Because D2 is a separate way to lose the money. That's where the district wants to evaluate and the parents don't make the child available.
And I've said this number wrong before, so pull the page instead of trusting my memory. In my head, it's 10 days. On the page, it's 10 business days, including any holidays that occur on a business day. Business days, not calendar days.
10 business days, 2 school weeks, near enough. And a holiday landing midweek still counts as one of them, so it doesn't stretch. 2 weeks, flat.
Counted backwards from the day the child stops attending, not from the day the family decides, not from the tour, from the removal.
And there's a second route nobody realizes is a route. Paragraph D1, I lets the parents do it at the most recent IEP team meeting they attended before the removal. Reject the proposed placement, state your concerns, state your intent to enroll privately at public expense. Said in the room, it counts.
I know the written route cold. Where I stop is what counts as saying it in the room, whether it has to land in the minutes. Cynthia?
The paragraph says the parents did not inform the IEP team, so the test is informing, not minutes. But if nobody wrote it down, you're relying on 4 people remembering one sentence a year later.
Order matters more here than anybody expects. Run it once, start to finish.
Step 1. Say it at the most recent IEP meeting you attend. Step 2. Or put it in writing at least 10 business days before you remove the child. Step 3. Either way, name your concerns and your intent to enroll privately at public expense. Step 4, then and only then enroll. Step 5. A hearing officer or a court decides whether the district pays.
Miss 1 and 2 both, and the money can be reduced or denied, not erased. Reduced or denied.
And honestly, telling every family to write a letter asks more than the regulation does. The oral route is right there in D1I. It's real.
You're right about the regulation, and I won't pretend D1I isn't a real route. So the question isn't which one the rule allows, it's which one survives a room that remembers the meeting differently a year later.
The written one. And it's a letter somebody writes during the worst week of their year, so name that cost out loud.
Writing anything during a bad week is its own problem. I took over the PTA newsletter 2 years ago, and I still owe those people a March issue, and nobody in my life is suing anybody.
You secretly love that newsletter.
I do. It's the only thing on my desk with a deadline I picked myself.
Okay, we're 3 exits past the topic. Back to the 10 business days. Written, dated, and before the child leaves.
I'm leaning in for this one because it's why this episode started with a packet nobody reads. Paragraph E1 says the cost of reimbursement must not be reduced or denied for failure to provide that notice if, for paragraph 2, the parents had not received notice pursuant to 504 of the notice requirement itself.
Yeah, sit with that one.
So Erica, if the district never handed her the packet, she keeps the whole thing?
The reduction can't be applied for missing that notice. Paragraph E1 is a must not a maybe.
So she wins the reimbursement.
No, she keeps her shot at it. Paragraph C still needs both findings, no timely FAPE, and an appropriate placement. Paragraph E removes one specific way of cutting the number, and there's a weaker list in E2 where a court may decline to cut it. May, again.
And to borrow Erica's word from the last scene, the freeze is a different tool than this. Paragraph B of 148 sends reimbursement fights into the same due process procedures. Same hallway, different door, one holds a placement, the other argues about a bill.
And the family that does this well walks their kid up the steps of a different building on a Monday, with a dated letter already sitting in the district's inbox.
A deadline you only learn about from its own pamphlet.
I've got no kids by choice and one rescue greyhound who sleeps through every recording, so nobody in my house has had to make this call, which is exactly why I default to the written route over anybody's memory of a meeting.
2 things to carry out of this, and neither is legal advice. 1. When a family says the word private in a meeting, the packet is what you point at, not your opinion. 2. That packet is the only reason a family ever learns the 10 business days exist, and paragraph E1 is why a district that skipped handing it over can't use the miss against them.
One is a right, the other is a rumor, documented.
And miss the 10 days with no packet excuse behind you, and the number can go to nothing.
If this made that packet less intimidating, hit like and subscribe. That's genuinely how the rest of this course finds the teachers who need it. I'll go first. I have sat in meetings where a parent had the packet open in front of them and I had never read a page of it, so. Have you ever read the procedural safeguards packet your own district hands out? Read it this week before somebody hands it to you at a table where it counts. This is Cynthia, and I'll see you in episode 17.